Morning, everyone. We'll just give it a couple of seconds to wait for some of you to join. We were expecting quite a few people with us today, so we will get going bang on the dot of 10 o'clock. But we'll just wait and embrace the slightly awkward silence that comes with waiting for the live webinars to get going. Okay, well, it's 10 o'clock. We've got a packed agenda for you to listen to today, so we're going to get cracking. So firstly, welcome to the next of our People Matter webinars. This one is an employment law update, so we have got all you need to know in the space of 30 minutes of what's changing in the field of employment law. And because it's election year, we've also got our crystal balls out and having a little look for what may well come down should there be, well, depending on the outcome of the election. For those of you that I don't know, hello, I'm Andrew Secker. I'm one of the employment partners at Mills & Reeve, and my co-presenter today is one of our rising stars. So that's Jameel Mann, who's one of our principal associates. So a warm welcome from the both of us to you. For those of you familiar with People Matter, you know the drill, but in case you've not been to one of these webinars before, let me just go over some of the basics as to how they're going to work. So we are recording this, so if there is a technology issue at your end, don't worry, you'll get a full audio recording at the end of this. But because we're recording it, the way in which you can engage with us is to give us any questions in the Q&A box that you'll find on the top of your ribbon. Likewise, what we would ask is at the end of this session, if we'd ask you to fill in a feedback form that will pop up automatically. We've got you for 30 minutes, and we hope we might squeeze in a couple of questions in that time period. But Jameel and I will be around after the allotted 30 minutes if you would like to stay on and ask us any particular questions. So housekeeping aside, what are we going to cover? Well, for anyone that's been following any employment law update since I think 2012, you'd be disappointed if we didn't have something on holiday pay. So Jameel's going to be talking about the legislative reforms that came into place in January of this year. We're then going to touch upon some of the reforms that are coming in respect of family-friendly leave. I'm going to call this our Back to the Future slot. So we've known about these reforms for some time, but we've got the detail as to what's changing and when. And so we'll cover that in some detail. We've then got an interesting pair of cases on unfair dismissal. So one's going to look at the extent to which certain types of misconduct can result in summary dismissal and what you need to communicate to your staff if you're going to have a zero tolerance of certain types of misconduct. Likewise, Jameel's going to cover a case about procedure in the context of an absence-related dismissal. And then, as I said, we're going to get our crystal balls out to have a little look for what's coming down the pipeline, both in terms of things we know. So there's a new code of practice potentially coming into force on hire and refire, but also what are the two main political parties in England talking about in terms of future reform of employment law. So that's what we've got. And to keep things moving, I'm going to pass over to Jameel, who's going to talk to you about holiday pay.
Thanks, Andrew. Yeah, we're going to kick off with some developments on holiday pay. So firstly, we're going to talk about some changes for regular workers. So there's some important Brexit reforms that took place on the 1st of January. And the government passed a new law which effectively rewrites EU law on holiday pay and discrimination into UK legislation, effectively to ensure that that law is preserved post-Brexit. But it has created a little bit of uncertainty, particularly around the new definition of normal pay, which we'll just come on to now. So first of all, we're going to talk about the introduction of the calculation of holiday pay for regular workers. So if we go back to basics, workers are entitled to 5.6 weeks holiday, which comprises of 4 weeks annual leave under the Working Time Directive and a further 1.6 weeks under the Working Time Regulations. So for a full-time employee, as we know, this equates to 28 days annual leave or 12.07% as a percentage, which is important for reasons I'll mention shortly. Now, the holiday pay due under the Working Time Directive, so the first 4 weeks, has to be based on normal remuneration. And the premise here is that employees must not be penalised for taking annual leave. Now, I mentioned the rules only apply to the first 4 weeks, but I know some of you will choose to pay full pay or normal remuneration for the 1.6 weeks as well. You can choose to only pay basic pay if you wish to do so for the 1.6 weeks. Now, the government's initial view when they looked at this was that the two different pots of leave we have is unhelpful. It can be a bit confusing, and therefore we should only have one single annual leave entitlement going forwards. But in the end, they decided to keep two distinct pots, and different rules applied to each. So the new regulations came into effect on the 1st of January. These amend the working time regulations, and they provide that certain elements should be included in the definition of a week's pay when calculating holiday pay for the first 4 weeks, such as payments including commission payments that are intrinsically linked to the performance of tasks which a worker is obliged under their contract to carry out, payments for professional or personal status relating to length of service, seniority, or professional qualifications, and payments such as overtime payments, which have been regularly paid to a worker in the 52 weeks preceding the calculation date. Now, although these regulations are intended to provide some clarity, there does remain some grounds of uncertainty and challenge. For example, what payments are intrinsically linked to the performance of tasks, for example, what payments have been paid with sufficient regularity. So the tribunals and courts will continue, I think, to have a role in addressing any residual uncertainty on these. The second change, which I'm sure you'll already be familiar with, we've seen this in case law previously, but it's now written in regulation, is in relation to an express requirement for annual leave to be carried over into a subsequent leave year in certain circumstances, including where the worker is absent on sick leave or statutory maternity leave, or, and this may be new to some of you, or is denied their paid annual leave entitlement. So employers must give employees a reasonable opportunity to take unused leave, or encourage them to take the leave, or inform them that any leave will be lost if it's untaken. And if a worker is unable to take any of their statutory leave entitlement as a result of any period of maternity or family-related leave, or if you as an employer fail to comply with these notification obligations, then they will be entitled to carry over up to 28 days of their untaken leave into the following leave year. If we can just go to the action points from some of these changes. So the main impact will be on workers with normal working hours, but whose basic pay does not vary with the times or days work is done or with the amount of work done. So, for example, those who earn a basic salary but might receive allowances or commission or overtime payments, for example. And in those cases, the additional pay element should be included by calculating the average weekly pay in the relevant period, which is 52 weeks before the start of the holiday, or if the worker has less than a year's service, the completed weeks that they've been working. If there are weeks where no remuneration was payable, or if they were on sick or statutory leave, you must discount these, and you have to go back a maximum of 104 weeks. You probably already give workers the rights to carry over certain holiday entitlement, but now you'll have to do so by default with no maximum, save the 28 days. So remind your employees to use it or lose it. Make sure you give them sufficient time to use their holiday entitlement. And as with a number of these changes, you're going to have to go back to your policies on holiday pay and make sure that they're amended to reflect this new requirement. If we can just go on to the next slide relating to changes for atypical workers. So the new regulations have also made some changes and some key changes to holiday rights for certain workers with irregular hours or those who only work part of the year. So here we're talking about workers with variable hours, 0 hours, workers term time only, workers, seasonal workers, for example. Now, these changes, unlike the ones I just mentioned, which came into effect on the 1st of Jan, these changes will apply from the 1st of April 2024 for those leave years commencing on or after the 1st of April. So if your leave year runs concurrently with the calendar year, they'll be effective for you with effect from the 1st of Jan 25. Now, the most significant of these changes is to how holiday pay is calculated for part-year and irregular hours workers, reversing the ruling in Harper Trust versus Brazil, which created a lot of confusion and resulted in part-year workers having more holiday entitlement than part-time workers who work the same number of hours per year, by saying that their pay should be based on an average of 52 weeks, even if they meant that that worker received a windfall. So there's now going to be a new accrual method for irregular hours workers and part-year workers. And holiday entitlement for these workers will be calculated as 12.07% of actual hours worked in the relevant pay period. So whether they're paid weekly, bi-weekly, monthly, for example. The second change is in relation to rolled up holiday pay. We know some of you will already be doing this, but rolled up holiday pay will be officially permitted. Employers will be allowed to pay a holiday pay enhancement on top of the workers' wages to replace their entitlement to holiday. Rolled up holiday pay will need to be calculated using the worker's total earnings over the relevant pay period again. So I'll come on to just some points on administrative thoughts on that. And finally, there'll be a new method for calculating holiday entitlement for regular hours workers and part-year workers who are on long-term sick leave or family leave, again using a 52-week reference period. Now, that reference period would run from the day before the worker starts their maternity or family-related leave or sick leave, and you go back 52 weeks. And again, when calculating the average weekly hours worked, you shouldn't include weeks where the worker is on maternity or family-related leave or sick leave for any amount. Weeks not worked for any other reason should be included. And if the worker has not worked for the 52 weeks, then you can shorten the relevant period to the number of weeks the worker's worked for you. Unfortunately, you're only required to perform these calculations once per period of leave. So if we can just go on to the action points. So you will need to review whether you have workers who count as irregular hours workers or party workers. I'm sure you'll have gone through this process previously, but I think you need to review your approach to holiday accrual and ensure it's compliant given this new legislative change that is either going to hit you in April or later in the year. If you do intend to start using rolled up holiday pay, you'll need to check your workers' contracts in case this amounts to a variation of contract. You also need to tell your workers if you intend to start using rolled up holiday pay, and for this payment to be clearly marked as a separate item on each pay slip. Holiday pay should be paid at the same time as the worker is paid for the work done in each pay period, and the holiday pay should be paid at the same time as the worker is paid for the work done. So check your systems are compliant if this is something that you want to look at. Right, I'm now going to pass over to Andrew. We're going to look at some family-friendly policies.
Thanks very much, Jameel. So in this section, we're going to talk about a number of the reforms. And what's quite interesting is that if you ever wanted to identify how ESG is really impacting on employment reforms, some of these changes have come from social movements. So the lobbying group Pregnant and Screwed were behind championed the additional protections needed for those who have taken maternity leave. So it's always a good example when you're using buzzwords like ESG and trying to find something specific as to what the consequence of that is. Well, these reforms are a good example. So let's turn to the first of these reforms, which is the changes to paternity leave. Now, the changes came into effect from the 8th of March, but they relate to children who, employees with children who are born or expected to be born on or after the 6th of April, and similar for those who have children placed for adoption with them. The basic concept of these reforms is to give a greater flexibility when exercising your statutory right to paternity leave than currently allowed. Now, this is drawn out quite neatly by the two boxes on the slide. So at the moment, you take your paternity leave in a single block of either 1 week or 2 week, and you have to take it within the first 8 weeks following the birth of a child or the placement of a child for adoption. So What's going to be changing moving forward is greater flexibility. So you can take it in 2 blocks. You can take it at any time during the first year after a child's been born or placed for adoption. And the period of notice you give for the specific period you want to take the leave has been reduced to 28 days. You still have to give notice of an intention to take paternity leave 15 weeks before, in the case of birth, the expected week of childbirth, but it's giving you a lot more flexibility. So whereas at the moment you couldn't do this, moving forward, it may be that employees can request a week's paternity leave just after, for example, a child has been born, and then take another week much later in the first year, so perhaps after, let's say, 9 months. So really trying to encourage a greater use of paternity leave from those with childcaring responsibilities. What does that mean in terms of specific actions? So there's a theme here about policy updates. Sorry if you give the game away from what Jameel's been saying. So it's a case of reviewing your paternity policy. Many employers offer a greater flexibility than the statutory scheme already. So it may be this is not a revolutionary change for you, but worth updating your policy if it does change. Tell managers there's greater flexibility. And then it's also a point of notification employees of their rights. You may also wish to have a look at those individuals within your workforce who are expecting children or to be born or placed for adoption with them between now and the 6th of April to see whether, as a matter of discretion, you would allow them to benefit from some of these changes. It kind of falls into my have a heart policy, because there's always, with these reforms, a bright line when the legal position changes, and that can sometimes be difficult for those, for example, with children who are expected to be born on the 5th of April to understand the statutory regime doesn't quite apply to them. That is paternity leave changes. And if I swing back to Jameel, who's going to talk about the changes in redundancy protection.
Thanks, Andrew. Yeah, so by way of background, if a redundancy situation arises during an employer's maternity leave, and it's not practicable by using a redundancy for the employer to continue to employ that individual, the employee is entitled, as we know, to be offered a suitable alternative vacancy if one's available. So this gives the employee on maternity leave priority over other employees who are at risk of redundancy, and is a rare example of lawful and positive discrimination, and failure to comply could amount to a potential claim of automatic unfair dismissal. Now, on the 6th of April, this right will be extended in a typical birth scenario to pregnant women and those who returning to work after maternity leave. So in a typical maternity scenario, the protected period will be extended, and it will begin with the date the employer is told about the pregnancy and end 18 months from the beginning of the expected week of childbirth. Now, the new rules will apply where the employee notifies the employer of the pregnancy on or after the 6th of April, or where the existing maternity leave ends on or after the 6th of April. So unfortunately, there's another clear action point here to update your redundancy and maternity policy, and also your managers on the ground need to be mindful and aware that this change is forthcoming.
Okay, so we then move on to carers leave, and it's been badged as a brand new statutory right, but hold up, don't worry, it's actually really familiar, because it's the easiest way, I think, to understand carers leave in trying to work out how it operates in practice. It's like a combination between time off for dependents and the existing right that employees have to unpaid parental leave, because those are the two concepts this has really been based on. So it essentially is a right that applies to employees who have a dependent with long-term care needs. Now, great example of my first point about it's not that new is that the definition of dependent is exactly the same as that used for time off for dependents. So it's dealing with a spouse, a partner, children, those that live in the same house as you, that's not a tenant, and those for whom the employee has a reasonable expectation of being there, responsible for their care. Long-time care is defined in one of 3 things. So it's those who have an illness or injury, whether physical or mental, that requires or is likely to require care for more than 3 months. Secondly, for those who have a disability as defined within Section 1 of the Equality Act, we all know that definition by heart, so I won't go through it. And thirdly, those who require care for a reason relating to their old age. Now, helpfully, or at least I would say helpfully, there's no evidential requirement to set out what the long-term care is. It's essentially a self-certification process. And part of that, and the reason I think it's sometimes helpful, is it's proportionate, because essentially it's only a week, but also if you start getting information about the care of a dependent, that's going to trigger all sorts of data protection issues. The way it works is you're entitled to a week's unpaid leave every 12 months. It's a rolling 12 months, and a week is helpfully relatively simple. It's your normal working week. So if you work 5 days a week, it's 5 days. If you have part-time or atypical arrangements, they essentially look over a rolling 52-week period and create an average. Or if you've worked less than 52 weeks, it's an average of based on the number of weeks you've actually worked. You can take it in a week, a day, or a half day, and there's some notice provisions. Importantly, just like time off for parental leave, you cannot refuse it, but you can postpone it, again, where it's not reasonably practical for the business. And again, like requests for parental leave, there is protection against detriment and dismissal if the reason for the detriment or dismissal is the fact they've exercised or sought to exercise their right to carer's leave. Now, what does that mean? Yeah, so no surprise, policy, but I think it also means a couple of things as well. Firstly, some record keeping. So you're going to need to record the self-certification of the caring need. You also need to keep some records of how much leave someone has taken, as you can take it in various things over a rolling period. And then you will need to communicate this to managers so they're aware of this right. I see carer's leave as being just part of the different rights. So it needs to be seen in conjunction with the time off for dependents, which is very much a short-term emergency need. This is about where they've got a long-term caring need that they need some support over essentially a 12-month period. So that's carer's leave. And we're going to then move on to have a look at a couple of cases on unfair dismissal. And I'm going to start with the case of Houston and Ofsted. Now, this involved, unfortunately, there's not much magic or in this reveal. It involves a school inspector who was dismissed following an issue on a school inspection. So essentially, it'd been raining outside. A pupil came in from outside with rain all over them, and the inspector touched the pupil's hair. And it's really important to emphasise that there was no safeguarding issue ever raised in connection with the contact between the school inspector and the pupil. Now, the school inspector was suspended and eventually dismissed, and it went to an employment tribunal, and the tribunal found the dismissal fair, and they were influenced by a couple of real key issues. So firstly, Ofsted said they had an absolute zero tolerance to any form of physical contact between their inspectors and pupils, and that was known. Secondly, they said throughout the course of the disciplinary, the inspector had defended their actions and said they hadn't done anything wrong, and therefore that undermined their ability to trust that the inspector would adhere to their zero contact policy. Case went to the EAT, and the EAT essentially looked in this in a lot more detail, and it made quite difficult reading for Ofsted, I'm afraid. When they looked at this, they said, well, you say there's a zero physical contact policy, but that's not set out in your disciplinary policy. It's not set out in the training you provide. And actually, when tested, they were satisfied that whilst there was some form of physical contact that it was clearly known would result in gross misconduct and therefore likely to result in dismissal, there was a big grey area, and therefore it wasn't clear that all forms of physical touching would result in summary termination. So therefore, treating that of itself as a gross misconduct for a first offence rendered the dismissal unfair. The second thing that came out as a consequence of this was they found that the over-reliance on the approach from the inspector to defend their actions was simply that, and therefore it wouldn't follow that there was a right to judge that they wouldn't comply with a zero tolerance of contact approach. Funny enough, I suspect what was also in the background is the EAT's decision records that the local authorities had reviewed this whole incident and just decided that there was only remedial action by the way of training necessary. But that report had been withheld from the inspector until they got into employment tribunal proceedings. So a key takeaway from me on this one is that insofar as you have certain forms of conduct which are zero tolerance within your organisation, to make sure that that's labelled within your policies. You can never list every single thing that would constitute gross misconduct in any disciplinary or even in any policies, but it's worth reviewing that from time to time as to thinking what standards of conduct do you want to call out. So that's what I can talk about with Houston. Jameel?
Thank you. So yes, I'm just going to very quickly go through a case involving British Airways. Headlines: always follow your policies. What happens when you don't always follow your policy? And this is a little bit of an unusual one, but there are some lessons to be learned. So Mr. Garcha Singh was a long-haul cabin crew member, and he was unfit to fly due to several physical health conditions. In August 2017, he was given notice that his employment would terminate the following January, but this was not set in stone and intended to be the date he aimed to be back in work. Now, after that date, the termination date was pushed back once, and then it was pushed back again and again. And the termination date was extended 7 times, spanning nearly a year. And that was really to give him further time to return to work if he could. Now, in amongst these extensions, he raised a grievance, which they effectively dealt with as an appeal. And he argued that the extensions to his termination date were effectively, well, first of all, he brought a claim in relation to the fact that the decision was unfair. BA ultimately ended his employment in December the following year, and he argued that the extensions to his termination date were effectively a breach of their absence management policy and a breach of contract. He wasn't given the right of appeal against the final decision, but that was really just a decision not to extend the termination date any further. Now, he argued that the absence management policy was contractual and contained a further right of appeal. Now, they had deviated slightly, but this wasn't fatal, and the EAT concluded that they couldn't cover every eventuality. They felt that overall the procedure adopted by British Airways was not in breach of contract and was within the range of reasonable responses, particularly given that every extension was actually to his advantage. They had given him a right of appeal. It's just that the final decision in December was just a decision not to postpone the termination even further. Now, the key points we want to make here are that although British Airways tried to do their best by extending this period, they effectively confused things a little bit. And sometimes it's more straightforward to simply serve notice and stand by that decision, subject to a right of appeal. However, there is always the possibility that when termination is a long time after the decision to dismiss, new information and circumstances could arise after that decision to dismiss that make it appropriate to offer further right of appeal, or at least require to check the decision to dismiss still stands. Likewise, if you do choose to extend the termination date to support an employee, such as, for example, in a redundancy situation where you're looking to avoid dismissal, this case can support you in demonstrating it would be fair and reasonable to do that. If I could just have the next slide in terms of what's coming up. I'm just conscious of time, so we're going to quickly just go through some of the things that on the horizon. So the government's published an updated code of practice on fire and rehire. We've covered this in quite a bit of detail previously. It's intended to come into force later this summer. We know that there's obviously a general election coming up. Labour aren't too keen on this approach, so whether that does come into effect or not, we'll have to wait and see, but it's just something to think about. There's going to be a new positive duty on employers to take all reasonable steps to prevent sexual harassment in the workplace. This will be coming into effect on the 26th of October 2024, and that will be supported by a statutory code of practice. The duty would actually be enforceable not only after harassment incident, but also without the need for any incident to take place if an employee can show that you haven't actually done enough to prevent harassment from taking place in the workplace. And tribunals will have the power to uplift sexual harassment compensation of up to 25% where you have been found to be in breach of the new duty. And finally, in or around April 2025, we should see a new right for parents of premature or sick babies to 1 week's paid leave for each week that their baby is in neonatal care.
Okay, I'm just going to pick up party politics. Before I did, I noticed, thanks to the question, I forgot to say that the carers leave is coming in from the 6th of April 2024. So just a key point on that. Look, in terms of what we know about the potential reforms in the general election, the Conservatives, helpfully, we have a flavour of by virtue of what's already in the pipeline. So Jameel talked on hire and fire. A key one also in the pipeline is the potential to ban non-competition restrictive covenants in excess of 3 months and make further restrictions on the use of NDA. So that's code word for confidentiality in settlement. To be fair, I think there's already some practice changing in that within the profession anyway. Labour's policies are perhaps slightly more, I'm not going to put this, neutrally bold. So we know that there's some stuff to expect of any Labour government. So they're going to repeal some of the restrictions that the Tories have put in terms of the ability to take strike action, although query if we need that given the effectiveness of the train strikes. But they're also looking at cross-sector collective bargaining similar to that seen in Europe. So that would be really quite revolutionary. There's wider changes that could affect risk decisions. So, for example, extending the protection from unfair dismissal as a day one right, extending the time period to bring claims in an employment tribunal to 6 months from 3, similar to equal pay, and essentially removing the twin employment status we have. You know, we've got this distinction between workers and employees to create a single worker status. So that's conferring a whole load of rights currently only enjoyed to employees to workers. So quite bold, quite punchy. And of course, I'm going to give a caveat for both of these political parties as we are in election year. It's possible that what they say now may not be what they end up delivering or promising, depending on all of the good things that can happen in an election year. So that's all that we've got. We're going to stay on for some questions outside the allotted time. For those of you that can't stay on for questions, please, can we just remind you to fill in, if you can, the feedback forms that will come up automatically. These sessions are improved by the feedback you provide. So thank you so much for taking the time to do it. And Jameel and I will happily just stay and answer a couple of questions. Jameel, as I've been talking, is there a couple that occur to you?
Yeah, so there's been a few on holiday pay. Some are quite specific, and there's some are on a similar theme. So we may get back to on specific ones, but the themes are some questions around sick pay, what happens if somebody can't take holiday due to sick leave. The position is that, you know, for regular hours workers, they can continue to carry over a minimum of 20 days, but they will have, rather than that being carried forward just for the next leave year, they'll have up to 18 months in which to take that leave. Another question was around employees and workers who've worked for less than 52 weeks. You just have to use the same calculation, but based upon the number of weeks that they've actually been with you.
Yeah, there's a couple of questions on the carers leave that pick up. There's a really good question that's been raised about whether a dependent has to be a relative. No, it doesn't have to be. And you don't have to prove your relationship with the dependent. That's absolutely also correct. It's a self-cert process, which I appreciate does create some nervousness as to whether or not it could be abused, but I think the primary purpose of it is quite good, and there's a balance of practicality when it's only a week's unpaid leave, and the lack of payment itself possibly becomes some form of deterrent. I'm going to pick a really dead easy question. Someone's asked, would the slides be shared with attendees afterwards? Yes, they do come out automatically. I'm just trying to see if there's any other questions we can pick up.
Yeah, there's just one other in relation to the extended redundancy protection. So just to clarify, the new rules apply where the employee notifies the employer of the pregnancy on or after the 6th of April, or where the existing maternity leave ends on or after the 6th of April. So that they're the two circumstances where the extended redundancy protection would be triggered.
Okay. Someone's asked, can carers' leaves be taken as single days? Yes, they can. They can be taken as days or half days. And I think there's been a couple of questions also asked about the rather thorny question of what constitutes regular in the context of overtime. If Jameel and I could give you an answer that was watertight on that one, we'd probably be worth quite a lot of money and have resolved an issue that's been bothering the Employment Tribunal and the appellate authorities for a number of years. But essentially, regular and recurrent looks primarily at an ordinary interpretation and looks at the reason the overtime is being worked. So is it because the reason for working the overtime is something that is regular or recurrent? So for example, you might take an accounts team that regularly receives overtime at the year end. Well, does the fact that they all routinely work overtime every year, let's say in April, just before an end of a tax year, or even March, constitute a regular recurrent? Well, almost if it becomes de rigueur that this is coming, it's really getting at that. So whilst we don't have there's a range of factors you can take into account. I think for me, the starting point in understanding whether something is regular is to understand why is it a payment is being made and how recurrent, and what's the reason for the recurrency. Is it becoming something that people are expecting that they may be required to do as part of their job?
Just a couple of very quick questions which have got similar themes as well, around what happens if you've got somebody who's got an entitlement to more than 28 days leave. So the entitlement to carry over is capped at 28 days, but if you've got more than 28 days, if you offer more than 28 days leave, I think it's definitely worth just flagging in your contract and policies that is the maximum that could be carried over. And question about whether what sectors does this apply to? All sectors? It does apply to all sectors, unfortunately.
Okay, we're beginning to understandably lose people as they're disappearing to get off to their next meetings or grab a cup of tea before their next meeting. So I think we'll bring that to an end. Just a reminder, if you could complete the feedback form, we'll look through the questions, and if there's some additional ones we can answer, then we'll get back to you. But just on behalf of Jameel, myself, and Mills and Reeve, thank you so much for joining in, and we hope to see you at a next episode of People Matter. Thank you very, very much.
Thank you.